The Supreme Court's not the last stop on the bus line. If Tom was kind enough to mention my national affairs piece, and my national affairs piece was in large part a counter-reaction exactly to panels like this, where everybody says, ooh, the Supreme Court is about to decide on something. Let's get a bunch of distinguished mandarins to interpret what the Supreme Court is going to do. And when the Supreme Court is done, the issue will be settled. The Constitution is a document written on behalf of the United States people, and it assigns responsibilities to all three branches of the departments of the U.S. government, and it assigns responsibilities to the states. All of those actors have some responsibility and authority to interpret the Constitution. And in the past, granted more often in the long distant past, Congress and the President took substantial ownership of the power to interpret the Constitution. So right after the Constitution was ratified in the first 15 years, the Federalists and the Republicans had a rollicking debate about whether the Alien Sedition Acts were constitutional. Most people think now that those debates were about free speech, but primarily they weren't. Primarily, the question was whether it was necessary and proper for Congress, in the course of carrying out its responsibilities to manage what might be a war against France, would need to pass a sedition law preventing criticism of the United States government. And the 1800 election was in large part a referendum on whether the Federalists had overstepped the sources of power the national government is given under the Constitution because they claimed the power to regulate allegedly seditious speech on the ground that it was necessary and proper. The Federalists lost, and President Jefferson pardoned many people convicted on the Sedition Act on constitutional grounds, and the Sedition Act lapsed into non-existence because that lapse was understood to be a choice by Congress to let the act die on constitutional grounds. 30 years later, or from the 1790s through the 1830s, there was a rollicking debate about whether the national bank was constitutional or not. And in McCulloch versus Maryland, the Supreme Court said that the national bank was necessary and proper for Congress to carry out its powers in relation to the national coinage, its powers to borrow, its powers to finance war-making efforts, and its power to manage interstate commerce. And in 1832, President Jackson said he vetoed a reauthorization of the bank, and he said he would give the Supreme Court's decision in McCulloch such force and weight as it deserved, but politely and with respect he disagreed. So if the Supreme Court upholds the mandate on constitutional grounds, people in this room and elsewhere shouldn't assume that's the end of the constitutional issue. There are other departments in the government, and there are states, and there are political parties that are entitled to say, with respect, if the Supreme Court thought that it was necessary and proper for Congress to do this, we can elect a Congress that thinks that it's not necessary and proper and repeal Obamacare on that basis.